You're listening to the Cyberwire Network, powered by N2K.
This episode is brought to you by Shopify. Forget the frustration of picking commerce platforms when you switch your business to Shopify, the global commerce platform that supercharges your selling wherever you sell. With Shopify, you'll harness the same intuitive features, trusted apps, and powerful analytics used by the world's leading brands. Sign up today for your $1 per month trial period at shopify.com/tech, all lowercase. That's shopify.com/tech.
Now what happens with Chevron overruled by Loper Bright if a petitioner challenges the FCC and the FCC says, we want you to do this or we're going to make this rule. Now, if they challenge that in federal court under the Administrative Procedures Act, the court can look at this with its own eyes and say, you know what, FCC, there is nothing explicit here, authority that gives you this ability to regulate orbital debris. Where are you getting this? And because they don't have that power of the Chevron Deference anymore, the court could probably say, you know what, you don't have the authority, and throw it out.
Hello, everyone, and welcome to Caveat, N2K Cyberwire's privacy, surveillance, law, and policy podcast. I'm Dave Bittner, and joining me is my co-host Ben Yellen from the University of Maryland Center for Health and Homeland Security. Hello, Ben.
Hello, Dave.
On today's show, Ben discusses a new appeals court case holding that geofence warrants are unconstitutional. I look at the Democrats' proposed platform on cyber. And later in the show, a segment from the T-Minus Space Daily podcast. Maria Vermasas speaks with Michael Listner, founder and principal of Space Law and Policy Solutions. They're talking about Chevron Deference, its repeal, and the effect on the regulation of orbital debris. While this show covers legal topics and Ben is a lawyer, the views expressed do not constitute legal advice. For official legal advice on any of the topics we cover, please contact your attorney. Strata is your solution for securing on-prem and cloud apps without the hassle of refactoring. Modernize legacy systems with MFA or passwordless authentication and ensure continuous identity availability across multi-cloud environments. Say goodbye to tech debt and hello to seamless integration. Strata helps you reduce stress and gain control over your identity architecture, enhancing security and efficiency. Join industry leaders like 3M, Navy Federal, and Kroger who trust Strata for their identity needs. Visit strata.io/cyberwire to share your biggest identity challenge and receive a complimentary pair of AirPods Pro. Don't miss out. Transform your identity management today at strata.io/cyberwire. And our thanks to Strata for being a longtime friend and supporter of this podcast. All right, Ben, lots to cover this week. It's great to be back. Why don't you start things off for us here?
So remember a few weeks ago when we covered a Fourth Circuit case dealing with those geofence warrants?
Right.
Where the government goes to Google or whomever and says, give me all of the devices that were in this area at this time.
Yeah.
Well, the Fourth Circuit held that geofence warrants do not constitute searches, and therefore people do not have any Fourth Amendment protection from those warrants. Unfortunately for us, there are a lot of circuits across the country. And the Fifth Circuit has decided to weigh in and came to the exact opposite conclusion in a case called United States v. Jamar Smith. And we now have a circuit split, which means, and I know we'll get to this later, I think this is headed straight to the Supreme Court.
Okay.
So this decision is both surprising to me and fascinating, and I think if you take the decision literally, has implications that go far beyond geofence warrants. So the first question the court answers in this decision is whether these types of warrants constitute a search. Basically, what the court in Chattree did, which was the Fourth Amendment, the Fourth Circuit case, is compared this to the search in Carpenter. So is a search for a device in a particular location at a particular time, does that violate somebody's reasonable expectation of privacy? And the most relevant Supreme Court case is Carpenter, which held that historical cell site location information, the collection of that, does constitute a search. There wasn't sort of an exact time frame on that. But when comparing the collection of the geofence warrant data to Carpenter, the Fourth Circuit basically said, it's not that similar. This data wouldn't really provide a wealth of information about a person. It's just not the same type of warrant.
Okay.
Fifth Circuit comes to the opposite conclusion. They say this is a search and that potentially the information gained through not just one geofence warrants, but once you obtain a single geofence warrant, you might go on a fishing expedition to find out where this person has been, what activities they've been engaged in. And you can use geofence warrants to see, well, was this device in these particular locations at these particular times? And if you find that a person has been at those locations, that can be significantly revealing to the extent that grants a person Fourth Amendment protection under Carpenter. So they hold that this is a Fourth Amendment search, meaning we now have a warrant requirement. And this is where things get really interesting. Warrants have to be particular. I couldn't just say the police can barge into Dave's house at any time of day and see what they can find. Just go in there, see if there's any contraband. You have to describe what you're searching, what you're intending to seize. There have to be some limitations on it.
So a warrant can't grant basically a fishing expedition.
Yeah, and that's what used to happen among our English legal ancestors. They would issue these general warrants where it's like, go into Dave's house, whatever you can find, we'll hold it against him. Like let's get this guy. You can't do that. There's this particularity requirement. What's fascinating about this case is the court holds that there is no way to fulfill that particularity requirement when we are talking about geofence warrants. Because the data set that we are searching is so incredibly broad, we are asking for not just the whereabouts of an individual device, but all of the devices in a particular location. And to obtain that data, we have to engage in a mass search of a very large data set. And so there's no way without knowing what you're searching for, because you use geofence data to figure out who was there, without knowing who you're searching for and the particular device that you are trying to discover, there is no way you could craft a warrant that would satisfy that particularity requirement. And as a result, geofence warrants are unconstitutional in the eyes of the Fifth Circuit. So a little bit on this last part of the holding about how there's no way you could craft a constitutionally permissible warrant.
Right.
If we applied that to basically all of the other cases that we cover on this podcast, I think it would have really profound implications because so much of our surveillance state depends on the ability to search for a tiny needle in a large haystack. We often don't know what that needle is, where it is. We're just trying to find some indicia of evidence or information. And if you extend the logic of this decision, any search along those lines is going to be constitutionally prohibited. Unless you have some level of particularity about the specific email address or social media handle or whatever that you're trying to search.
Right.
If it's overly general in the manner of a geofence warrant, then it's unconstitutional. So you can think of a lot of examples where maybe you would not be able to establish probable cause that somebody's been communicating with terrorists, but you search millions of call detail records to see if maybe you can discover this phone number somewhere in there.
Right.
Without any indicia that the phone number is going to be part of those records to see if a person was talking to a terrorist. If you extend the ruling of this Fifth Circuit decision, that type of search would not only be unconstitutional, there is no way you could make it constitutional. There's no warrant you could craft that would make it pass constitutional muster. And that is it would be a really profound holding.
So just for clarification for my point of view, let's differentiate between two things and make sure that I'm thinking of this correctly. So let's say somebody holds up the local 7-Eleven.
Yes.
Right? And the police...
A friend of yours. It wasn't you.
Well, maybe it was me. So the police are interested in me, right? So the hypothetical would be that in one case, the police are interested in knowing everybody who was at this location. They're not sure who might have been here, and they want to comb through the data of everybody who was there, everybody who went to this 7-Eleven. In the other instance, the police have a feeling that this bad dude, Dave Bittner, might have been the person who held up this 7-Eleven. So then they go and in their warrant, they say, we want to know if Dave Bittner was at this location at this time.
Yeah, so that second search would be permissible and that first search would not.
Got it.
But oftentimes you have to go through the process of that first search to even start to compile evidence.
Right.
By doing that initial geofence warrant, you get a list of phone numbers that were in the area, and then you do some investigative work. Oh, this guy is Dave Bittner, and his phone
notorious
number
7-Eleven thief.
Yeah, has been connected with the theft of 50-cent coffee cups from 7-Eleven.
All up and down the East Coast.
Yeah, he is the
He's
notorious
one step ahead of the law. Yeah.
7-Eleven thief.
Right.
So that, this court would say, is constitutionally impermissible. They go through how Google performs its geofence warrants. There is a database called Sensor Vault, and Google, when performing a search pursuant to a geofence warrant, necessarily searches all 592 million individual accounts of Google users across the world. And what this court is saying is that while Google is searching all 592 million records, law enforcement have no idea what they're looking for and whether the search will turn up a result that's even remotely relevant to the crime that they are investigating. And for that reason, there's no way you could possibly craft a warrant. It's impossible. There's no level of particularity. It's basically a per se holding that geofence warrants are unconstitutional, which I think is really profound and fascinating, and of course creates this significant circuit split.
Mm-hmm. In your opinion, did the Fourth Circuit in their ruling make a reasonable argument for their ruling?
I think so. In terms of the question of whether there has been a search to begin with, which is the only question the Fourth Circuit considered, I can see both sides of the argument. I don't think geofence warrants are analogous to the search in Carpenter, because Carpenter was focused on one individual. They had their suspect. They were looking at weeks worth of historical cell site location information, which was very specific to Mr. Carpenter and his location. A geofence warrant in and of itself does not do that. It's only related to one single location. It's not related to a single person. The only piece of data, snippet of data that you could obtain and use against somebody is that they were in one particular location at one particular time. To me, that's not so analogous to Carpenter that I would rely on Carpenter to say that a search had taken place. So in that sense, I think I kind of agree with the Fourth Circuit. And once the Fourth Circuit held that there was no search, they don't have to go through the rest of the Fourth Amendment analysis. They don't need to determine whether you could issue a warrant based on probable cause. If it's not a search, go for it. You can do anything.
Right.
The Fourth Amendment only prohibits unreasonable searches and seizures that are not supported by a warrant based on probable cause.
So as a fan of civil liberty, I suspect you're cheering on the Fifth Circuit here?
If you are a civil libertarian, yes, you are cheering on the Fifth Circuit and this 3-judge panel. I will note all Republican presidential appointees.
Interesting.
I believe it's 1 Reagan appointee and 2 Trump appointees on this panel. And that's fascinating to me because the Fourth Circuit, the majority opinion in that 3-judge panel was drafted by Republican-appointed judges, and the dissent was from a Democratic-appointed judge. So this does not fall neatly along partisan lines. I think if you have a concern that geofence warrants violate civil liberties, then I think you're thrilled with this Fifth Circuit decision. If you are somebody who has a more balanced approach and wants to make sure that law enforcement can access these types of tools to solve crimes, then I think you're worried, if not disappointed. I think law enforcement agencies, especially the feds, are going to be very fearful that the logic of the Fifth Circuit gets extended. Now, before we freak out about it, law enforcement agents, I'll note that the Fifth Circuit's record in front of the United States Supreme Court is about as impressive and proficient as the Chicago White Sox are in Major League Baseball. No offense, White Sox fans, but if you don't get that reference, you can look up what their record is. It's not good. They've had a lot of their decisions overturned in the past couple of years.
Interesting.
So just because the Fifth Circuit came up with this decision, that does not mean this holding is going to last.
Am I correct that the Fifth Circuit is It has a reputation for being very conservative?
It absolutely does. It is the most conservative circuit, the largest majority of Republican-appointed judges. So the odds are you were going to get a panel like this with very conservative judges. They did, but you happened to get a panel that was deeply skeptical of the government's ability to obtain these warrants. So one thing we should note is that Google announced late last year that they're voluntarily discontinuing the technology that allows them to comply with geofence warrants. So there's certainly a question about the mootness in this case. This was a case about Google. Now, other companies fulfill the same function as Google as it comes to location data. Obviously, they don't have as much of a market share. So that's just another interesting element in this case. I think if the Supreme Court wanted to punt on the issue, they could rule and say that the case is moot because Google no longer compiles this data. I don't think that's what they're going to land on because you do have a suspected criminal here. And just because Google discontinued the collection, it was still used to prosecute the particular criminal in this case. So that's not going to get us out of this bind, but I think that's something to look forward to as this case makes its way up to the Supreme Court, or if another similar case dealing with geofence warrants from a different circuit makes it up to the Supreme Court.
Now, help me understand with the circuits here. Does this mean that if I'm living in a place that's under the jurisdiction of the Fifth Circuit Court, that there's one set of rules, but if I'm living where the Fourth Circuit is, then it's different?
That's exactly right. So if you are worried about being targeted by a geofence warrant, I encourage you to look up the states that are part of the Fifth Circuit and move there. There's a lot of sunshine there. It's most of the southern tier of the United States.
Okay.
So Texas, Mississippi, Louisiana, some beautiful land down there. And at this particular time, you are free from the threat of geofence warrants.
What's the pathway for this to head to the Supreme Court?
So my guess is that the United States, which is prosecuting this case, will try to appeal this decision. First, they will try to get an en banc hearing with the entire Fifth Circuit panel. If that is not granted, they will seek certiorari at the United States Supreme Court. And if 4 justices agree to take up this case, then we would potentially get a resolution to the circuit split on geofence warrants. So we'll see if the Supreme Court grants cert. We probably wouldn't find that out for a little while just because I think they have to go through the process of appealing to the full Fifth Circuit first before they appeal all the way up to the U.S. Supreme Court. But I would not be surprised at all if this is the case that makes it up to the Supreme Court. I would not be surprised at all.
Wow. All right. Well, stay tuned for that. We will have a link to that story in the show notes, of course. I want to look this week at some of the policy announcements that the various parties have made when it comes to cybersecurity and technology. As we record this and as this is going to air in a day or two, we are hot and heavy in the week of the Democratic Party having their convention, where, of course, Vice President Harris and Governor Walz will certainly be selected as the candidates for their side in the upcoming presidential election. And so the Democratic Party has released their 2024 platform, and it has, I have to say, I'm not sure if it's fair to say it's noteworthy that it doesn't say a whole lot about cyber, given where we are in the world today.
Can I say something about the platform before we even get to the content of the cybersecurity stuff?
Please.
Somebody should have done some copy editing because they clearly wrote the platform before President Biden dropped out of the race.
Right.
And at like 20 separate points in the document, it says, in President Biden's second term, like find and replace people.
Yeah,
Not
right.
that hard.
How hard is that?
Yeah.
How hard is that? Yeah.
But beyond that, yes, there are some interesting cybersecurity elements in there.
So the platform mentions cybersecurity or cyber 3 times. There's a section on criminal justice, and the platform says, we will remove barriers to legal access, combat hate crimes, and counter cyber threats. So
countering cyber threats, cool.
That's great. Non-specific.
Sounds like all of our problems will be solved.
Right.
Good to know that we're going to counter those cyber threats.
There you go. There's a section titled Protecting Kids Online, Strengthening Americans' Data Privacy and Promoting Competition. And in that, the platform says, The president has raised the alarm that social media and other platforms have allowed abusive and even criminal conduct like cyber stalking, child sexual exploitation, and non-consensual intimate images to proliferate on their sites, and called on Democrats and Republicans to unite on legislation to address these issues.
This one is somewhat notable because we have these internet child safety laws making their way through Congress right now.
Right.
The Biden administration, including presumably Vice President Harris, have endorsed these bills. Just before Congress went on their summer recess, the Senate passed a version of these bills. They're twin bills dealing with kids' online privacy. There's a lot of opposition in the House of Representatives. So there's a lot of doubt as to whether the House will agree to this prior to this session of Congress ending at the end of the calendar year.
Yeah.
So it's notable that the platform says that they are endorsing this position. It's not surprising, but it is certainly more relevant in particular than we're going to counter cyber threats. So that's good.
Yeah, and I think just this morning, as you and I were getting ready to record, I saw a couple of headlines come by that I think California's recently passed legislation that was basically a protect the kids in cyber law got shot down because it has constitutional issues.
Yes,
So,
I think that might be a preview of coming attractions of a future episode of ours.
yeah.
Spoiler alert.
And then last but not least, in the Democratic platform here, there's a section titled Strongest Military in the World. And it says that President Biden
Yep.
will continue to address cyber threats by bolstering the capacity of our intelligence communities and lead the development of rules of the road for technologies like artificial intelligence.
He'll be doing that in his bathrobe at Rehoboth Beach.
That's right.
Yeah.
He'll be texting from
Kamala, one last thing that I forgot
enjoying
when we were
his
there.
retirement. Yeah.
Will you do the cyber stuff? Yeah, I mean, this also seems boilerplate to me. It is very important that we continue to address cyber threats. I think that's increasingly part or should be part of our national defense strategy. I think the most recent kind of wake-up call for all of us was the CrowdStrike incident, just how vulnerable we are. That wasn't even a malicious attack. That was an update gone wrong, and we still suffered significant kinetic effects. If you don't believe me, ask any passenger who was booked on a Delta flight.
That's right. That's right.
So if that kind of impact occurs from a relatively small incident in the grand scheme, in the grand global scheme, then I think it should leave us worried and certainly anxious about a broader cyber incident, particularly against critical infrastructure. So I think it is boilerplate, but I'm glad it's in there.
Yeah, it seems sort of broadly aspirational, which I suppose is one of the purposes of a document like this. You don't want to get mired in the specifics and...
Yeah, it's more an expression of values. I don't think you want to lock yourself into specific policy proposals because through the sausage-making process in Congress, it's going to change anyway. So if you promise something in your platform, it's very likely that it's going to be watered down in Congress, and then your opponent in the next election can say, hey, you broke your promise. I think parties increasingly have just skewed toward less detail in their presidential platforms. I'll note that the 2020 Republican platform was basically what we said in 2016 is still our platform, and we support President Trump. And this year's Republican platform, I encourage you to look at it. It's a lot of capital letters. It kind of it looks as if you're reading a series of Trump posts on Truth Social.
Oh, just stylistically, you mean?
Yeah. So, the Democratic platform is kind of vague and boilerplate. The Republican platform seems very catered to their particular presidential candidate.
Well, let's dig into that. I mean, so I've got, looking back on the GOP's convention back in July, this is reporting from The Record, and they had a policy roadmap that committed the GOP to use all tools of national power to safeguard U.S. critical infrastructure from malicious cyber actors. So they were really coming at it from the critical infrastructure point of view.
Which is good. I mean, that's important.
Absolutely. Yep. Absolutely. But also looking at Chevron Deference, they are looking at repealing President Biden's what they refer to as dangerous artificial intelligence executive order that was issued last year. They say that the directive hinders AI innovation and imposes radical left-wing ideas on the development of this technology. In its place, Republicans support AI development rooted in free speech and human flourishing.
Well, that'll solve all our problems.
Well, I mean,
just as vague as the Democratic platform.
It's as vague, but it's also it's interesting to me how different in tone the two are, right?
Yeah, this is a little more adversarial. I think that just might be the nature of the parties. There is this focus on...
And the candidates, right?
Candidates, totally.
Former President Trump certainly is he doesn't back away from being direct or adversarial.
Yeah, never has and never will.
Yeah.
And if that fighting spirit is applied in the correct manner, I think it can be successful. The best example is Operation Warp Speed, probably the best public health program in this country since President Bush's PEPFAR aid to Africa in the fight against HIV. So when President Trump applies that sort of we won't back down spirit to something, we got vaccines in a very short time period,
right,
which helped end the COVID-19 pandemic. So I think just because the words are strong doesn't necessarily mean it's something to be concerned about. It's just kind of the way he talks. In terms of the content here, I think one area of concern about the so-called Project 2025, which is a 900-page document written by mostly former President Trump staffers at the Heritage Foundation, which is a conservative think tank.
Right.
The one area of concern for me is what would happen to the civil service. You have a lot of professionals who are non-political appointees, non-political staff members at these agencies. Think of CISA, think of NIST, think of the Department of Homeland Security, people who are fighting these cyber threats, many of the guests on our podcast. And Project 2025 would make it easier for the President of the United States to fire these individuals without any particular cause, just because they don't align with the administration's goals. And that, to me, is dangerous because I think you want to maintain that level of subject matter expertise, particularly as the threat landscape continues to be significant and threatening.
All right. Well, we will have a link to stories on both of the parties' policy statements in the show notes. And, of course, we would love to hear from you. Our email address is caveat@n2k.com. The IT world used to be simpler. You only had to secure and manage environments that you controlled. Then came new technologies and new ways to work. Now, employees, apps, and networks are everywhere. This means poor visibility, security gaps, and added risk. That's why Cloudflare created the first-ever connectivity cloud. Visit cloudflare.com to protect your business everywhere you do business. Ben, we've got a special interview segment this week. This is the host of the T-Minus Daily Space podcast, Maria Vermazis. She spoke with Michael Listner, who is founder and principal of Space Law and Policy Solutions. They're talking about Chevron Deference, which certainly we've talked about, and the effect on the regulation of orbital debris. Here's Maria Vermazis speaking with Michael Listner.
1984, the Supreme Court heard a case called Chevron. And what this case involved is a petitioner came to the Court of Appeals, or the district court in this case, and they had a ruling they didn't like from a federal administrative agency. And because they didn't like it, they were saying that basically, Congress did not give the agency the authority to actually rule in the way it did. The agency argued that the court doesn't have the expertise to decide what this silence in the statute means. And we think we actually have the authority to, where Congress is silent or ambiguous, to actually fill in the blank, so to speak, or, create or fill out the law in a sense and regulate from there. So this got all the way up to the Supreme Court, and the Supreme Court basically said, you know what, we agree with you, federal agency, and we're going to make this little test here for the lower courts to follow from now on. It came to be called the Chevron Deference. And basically what it says is if a regulation is challenged because of ambiguity or silence by Congress in the federal court under what we call the Administrative Procedures Act, the court's got to look at three things. It's got to look at first whether or not the actual agency has the force to actually implement the statute. In other words, did Congress give them the authorization to enforce this statute? And if they did, we're going to look at the regulation and look at the statute. And in the first step, if the statute is either silent or ambiguous to it, we're going to look at that and say, okay, if it is, and then we're going to go to step two. And basically what step two says is, you know what, as a court, we would normally look at these things and on our own decide whether or not, there was ambiguity or what the silence meant or whether you had the authority to rule on all. But because of the Chevron deference that was decided in Chevron, we're going to look to the administrative agency and you're going to tell us, you know what do you think it says? And the administrative agency will tell us what in their opinion, what it means. And if we, quote, find that reasonable, the court says we're going to have to say, okay, we agree with you and we'll rule in your favor because of that. So in other words, what the Chevron deference did and what Chevron did in general was it took the power of the court to review these cases on its own with its own eyes and actually deferred to the administrative agency's interpretation of a silence or an ambiguity in a law that authorized them to regulate in the first place. So in other words, Chevron basically put a thumb on the scale. And it gave a lot of power to basically unelected officials, to a bureaucracy, to the administrative state. It did, instead of allowing the courts to actually decide these things on their own.
I appreciate that. And so with Loper Bright Enterprises versus Raimondo, which that decision came down not that long ago in 2024, Chevron deference has basically gone away, is my understanding. Again, I'm not a lawyer, a legal expert, but my in a nutshell understanding is that no longer is valid. So, there are a lot of federal agencies involved when it comes to different areas of space. Is this a cataclysmic change overnight? Is this something where, we're going to be starting to see decisions taking longer as they need to go through the courts? I mean, what is this actually going to look like now that deference is not in play?
Well, we're going to see actually administrative agencies, including those that authorize commercial space activities, having to really point to an actual statute. And let me give you an example. The Federal Communications Commission licenses space activities that involve spectrum, the radio spectrum, which they regulate for satellite TV, satellite radio, and other communications. They basically have authority to regulate and license those types of activities. Now, Congress gave them this authority under the Communications Act of 1934. One of the things the FCC has done since I believe it's 2020, they said because we think we have the power to license these space activities, these involving radio spectrum, we also have the power to regulate what we call orbital space debris. In other words, we can require you to submit a plan to dispose of your satellites when they're done and other things, including, saying you have 5 years to get your satellite out of orbit after it fails, after it's no longer functional. But the thing is, in the Communications Act, there is no specific authority that says anything about orbital debris. Instead, what happened is the FCC pointed to a portion in the Communications Act that basically gives them the power to regulate anything that's in the public interest or that the FCC feels is there to protect the public sector. So this says nothing about it. They've been regulating space debris or orbital debris through their licensing power for the past 20 years. Now what happens with Chevron overruled by Loper Bright if a petitioner challenges the FCC and the FCC says, we want you to do this or we're going to make this rule. Now if they challenge that in federal court under the Administrative Procedures Act, the court can look at this with its own eyes and say, you know what, FCC, there is nothing explicit here, authority that gives you this ability to regulate orbital debris. Where are you getting this? And because they don't have that power of the Chevron deference anymore, the court could probably say, you know what, you don't have the authority and throw it out. Now, what does this mean? It means that if the FCC wants to regulate, Congress has to step in and basically do its job and put that language explicitly in the Communications Act and give the FCC that authority. Loper Bright says two things. One, it gives the courts back their power to review it and be independent in their reviews without having the thumb on the scale by federal administrative agencies. But it also puts the onus on Congress. You got to start specifically, explicitly giving these administrative agencies the authority to do it. It's what we call separation of powers. In other words, the executive branch, the legislative branch, and the judiciary, they all have their function to keep each other in check. What Chevron did is it basically put the thumb on the scale and gave the executive branch more power than it was supposed to have, and basically left Congress, lazy in a sense, because they weren't explicitly telling these agencies, you will give you this authority, or saying you don't have this authority.
Yeah, it completely makes sense. The FCC was a great example because, a lot of people do often ask, what on earth is the FCC doing about orbital debris, and why? Why is that their thing? So I guess the question is, in my mind, in this specific example, if what you were walking us through were to happen and in Congress does nothing, then because Congress being what it is, what would happen in that case? Is it just, I'm wondering, is it gridlock or what? Where does that go?
Well, it depends on whether a petitioner, let's say I am company XYZ and I'm going to launch a communication satellite. I got to apply to the FCC for a license to use spectrum, and basically they're going to be my primary authority to license my space activity because I'm dealing with the radio spectrum. The FCC is going to review my plan and say, you know what, you got to have this orbital debris plan. Oh, by the way, we decided we're going to make these new rules about orbital debris you've got to comply with. Now, you know what, I may not be upset about, doing an orbital debris mitigation plan because, well, it's a good thing. But on the other hand, this new requirement that they just pulled out of the air, which they actually did that last year, they pulled a 5-year rule out of their hats. This is going to be onerous for me. It's going to cost me money. I'm going to have to make some plans for the future about this. I don't think this is a good thing. So first step is I have to, file for a motion for reconsideration with the FCC saying, look, you know what, we want you to reconsider this. The FCC would probably say no. Then I would go to the Federal District Court or the Court of Appeals and file a suit under the Administrative Procedures Act. I would basically allege, you know what, the FCC does not have the authority to tell me that I have to abide by this 5-year rule because there's nothing in the Communications Act that says it. Now, the court, with fresh eyes and being able to act as an independent body and not having the thumb on the scale, they might look at it and say, you know what, FCC, show me where in the Communications Act you have this authority. And they would point back to that very ambiguous provision where it's absolutely silent on orbital debris and say, well, we use this. And the court says, but I don't see anything about orbital debris that says anything about satellites, orbital debris, what have you. You don't have the authority to do this. And basically the court say, you know what, the 5-year rule is, basically unconstitutional because the FCC does not have the authority to actually regulate orbital debris. So that could basically bring the whole house of cards on their ability to regulate orbital debris down, right? Make it a big mess. So what would happen then? Congress would have to act. Congress say, you know what, this is important. We got to pass an amendment to the Communications Act. And this will give Congress the ability to say to the FCC, we're going to give you this authority, but at the same time, we want you to coordinate with other agencies when you make these orbital debris rules so there's consistency throughout the federal government, because that's been an issue in the past.
It's a fascinating case study to be thinking through because I imagine a lot of federal agencies are very busy right now trying to figure out what kind of language they might want if they are advocating for something being put through by Congress. I imagine there's a lot of very busy people right now. A question I am thinking of right now is, the issue of regulatory burden is a big one in space. This patchwork quilt of who you have to go to for certain activities is confusing and difficult, especially for smaller orgs. This is just hypothetical, but do we think that the regulatory burden will be eased at all through the removal of the Chevron deference, or do you think it's sort of not even applicable in this case?
That depends, because there's a bill in Congress right now that wants to basically actually shift the authorizing authority to, say, the Department of Commerce. And it's basically HR 6131, and that's currently in this Congress. If you can read it, they want to take the current licensing scheme and give them a lot more authority, including dealing with orbital space debris. However, the National Space Council, through the White House, came up with their own idea what they want to see, which completely dismantles what we have now and creates a whole new system. And it's going to be an absolute nightmare if it gets implemented, which it probably won't. I don't think either of them will actually see the light of day. That bill is going to die for sure at the end of the year at this rate. And I don't think you're going to see the White House's version or what they want to see actually come to fruition. So, you have on one side where Congress is trying to make things a lot more streamlined and simpler. And I think what the White House and National Space Council want to do is create a whole new monstrosity that's going to make things immensely more difficult and expensive for private operators to actually perform space activities.
It's going to be very interesting to see as things sort of, the knock-on effect, but also as things sort of start to trickle through with Chevron Deference being gone now, when we see lawsuits coming through and if how that may or may not change things. And then if Congress will, as you say, do their jobs and actually, give, agencies authority if they so deem, necessary. So, it's going to be very interesting for you years,
well,
I'm sure.
Here's the thing, this is, it's Loper Bright is not a magic bullet that's going to automatically, change everything overnight. Somebody has to step up and actually file a suit in court because that's the way our system works. They got to challenge it. Now the question is, if I'm trying to get my space mission licensed through, say, the FCC or the FAA, do I really want to upset the apple cart right now and make people unhappy and have them and potentially get some blowback and have them delay my mission, or do I want to just stand up and say, you know what, this has got to be faced. We have the legal ammunition now. We're going to go in and we're going to challenge it. So it's a matter of a company stepping up and deciding whether it makes business sense for them to actually challenge this or not.
Ben, this is fascinating, right?
I love this. There's a Chevron angle on everything.
Right?
It can seem so abstract and technical. It's a Supreme Court decision dealing with deference to administrative decisions like that. People are bored just reading that sentence. But all of the different areas it can apply to, because it applies across federal agencies. And the fact that courts now do not have to grant deference, at least as an initial threshold matter, to the agency is significant in that it's going to impact all different types of regulations, ones that you probably haven't thought of. And for me, that was regulations relating to orbital debris, which I have never studied.
No, and the folks who are, who are involved in space tell me that this is a serious issue. It's both a serious issue for all of the other stuff that's up there, the satellites, certainly the International Space Station where there are people, but also there are environmental issues of this debris burning up in the atmosphere, which can have detrimental effects on the atmosphere itself. So I'm with you. It's really fascinating how much this decision on Chevron Deference just touches all different areas that you don't even think about.
Yeah, and I think it's going to take us a while to understand the true reach of this decision. I mean, we have to go through the process of agencies promulgating regulations, those regulations getting struck down because courts don't have to be deferential to an agency's interpretation, and then living out the consequences of those decisions. And it's going to take a while.
Yeah. Well, I highly recommend, if you are a space nerd like me, do check out the T-Minus Daily Space Podcast. It's lots of good stuff on there, just like this interview with Michael Listner. Again, he is the founder and principal at Space Law and Policy Solutions, and we appreciate the T-Minus gang sharing this great interview with us. And that is Caveat. We want to thank all of you for listening. We'd love to know what you think of this podcast. Your feedback ensures we deliver the insights that keep you a step ahead in the rapidly changing world of cybersecurity. If you like our show, please share a rating and review in your favorite podcast app. Please also fill out the survey in the show notes or send an email to caveat@n2k.com. We're privileged that N2K Cyberwire is part of the daily routine of the most influential leaders and operators in the public and private sector, from the Fortune 500 to many of the world's preeminent intelligence and law enforcement agencies. N2K makes it easy for companies to optimize your biggest investment, your people. We make you smarter about your teams while making your teams smarter. Learn how at n2k.com. This episode is produced by Liz Stokes. Our executive producer is Jennifer Iben. The show is mixed by Trey Hester. Our executive editor is Brandon Karp. Peter Kilpie is our publisher. I'm Dave Bittner.
And I'm Ben Yellen.
Thanks for listening.